Hi friends, so in this video I am going to tell you a nutshell of IBC case laws. Now I will make it very clear. I will not tell the case laws names because it is very difficult to remember all the case laws. In fact, if you are not writing the case laws names also, even if you can write the content of the case, that is more than enough. So I am very clear. Even in the previous attempt I told the same. Now also I am saying the same. It is difficult to remember the case laws name because most of the case laws have respondent and petitioner name which cannot you cannot pronounce the name of the 50% of the case laws, and it is waste of time to remember the case laws. Better you understand the case study content, okay? And I will make it very short so that now you can remember the content of the case. Point number 1, valid demand notice under IBC is must. So demand notice sent under something or some other act is not going to serve. Valid demand notice under IBC is must. Then demand notice to be sent to the right address. Demand notice sent to the wrong address is not a valid demand notice. Demand notice should also be issued. If the advocate is issuing the demand notice, he should have a power of attorney in his favor. So if the company is going to ask advocate to send demand notice, then the advocate should have the power of attorney in his name. Then certificate from the financial creditor that the debt amount has not been received in the operational creditors book. The certificate from the banker is dispensed with. Certificate is now optional. The creditor need not get the certificate from the banker to prove that he has not received the amount from the debtor. Certificate is now optional. 14 days time limit for accepting or rejecting the petition by the NCLT from the date of application filed. The 14 days time for accepting or rejecting is only an optional or discretion. It is not mandatory for NCLT to accept, okay, that within accept or reject within 14 days from the date of filing. But ultimately the end period is fixed. This once they accepted and they start the moratorium, that end period is already fixed, so you cannot ask the extension and all. That means like, yeah, extension is already there, 180 plus 90 is there, but not beyond that. Next, no other existing act can override IBC. So like no some industrial act of that local state will give some vacancy or some time period for insolvent persons or the debtor, but nothing will work. IBC will override everything. Then in case if the bank is giving wrong details, that means like there is a difference between the amount claimed as per the demand notice and amount they filed the notice with NCLT, application with NCLT. If there is going to be different amount, then NCLT will going to reject the petition and fine the bank if possible. Then if committee of creditors, if committee of creditors agree for withdrawal of petition, it is allowed to withdraw the petition. In fact, most of the case, 90% of the committee of creditors as well as debtors, if they are agreeing, 90% of the committee of creditors, if they are agreeing, they can withdraw the petition. Now it become the section itself. Previously it was a case law. Then sir, if the financial creditor is a related party for the debtor, can the financial creditor assign their dues to a other than related party? Yes, it is possible. Assigning of dues is now allowed in IBC. So many cases they have assigned the dues. So another unrelated parties, generally they will follow up and get the dues, and they will become the member in COC committee. Then home buyers or financial creditors, that we already discussed in the previous attempt itself. Then sir, moratorium, whether it is available for the guarantors. See, there are two contrary views. For that you should understand section 14 and section 101 of IBC. Section 14 says moratorium for the debtor, and section 101 talks about for the guarantors. Strictly speaking, actually speaking, guarantor should be given moratorium period, but actually they are two different part. I think it's in part 3, and according to me, the moratorium of this people know, that is debtor, will not be the same moratorium for the guarantors. But at the same time, if you want to initiate the IBC proceeding against the guarantors, you have to apply for a petition one more time for the guarantors. Okay, but there is no moratorium period for the guarantors. Okay, so but some high court are giving stay order for that. Okay, that is possible, but Supreme Court clearly says that there are two different provisions. This moratorium is not applicable to them. That's what Supreme Court told. Okay, then sir, if SARFAESI is started already, SARFAESI proceeding is started already, now IBC proceeding started, whether moratorium will apply now? Yes, moratorium is applicable even if the SARFAESI proceeding started already. Then sir, once IBC started, can we people go for arbitration? No. Once IBC started, you cannot go for arbitration. If you want, you can withdraw the petition and then you can go for arbitration. So that is up to you, the 90%. Then sir, can a pending share application money be treated as financial debt? No, it will not be treated as financial debt. Then sir, if a person goes to consumer forum and got some award in his favor, so can the award of consumer forum be treated as operational debt? Yes, it is possible. Arbitral award, consumer forum award can be treated as operational debt. Then NCLT or Supreme Court told, please see three things, okay, NCLT, before giving any decision. Point number one, whether there is a debt and the amount is exceeding the prescribed limit. Okay, if it is corporate debtor or it's a individual person, it depends, 1 lakh, 1000, etc. Point number two, whether there is a documentary evidence of payable and receivable. Point number three, whether there is no dispute pending. Okay, these three things you should always keep in mind before giving any judgment. Okay, then can NCLT remove the RP, that is resolution professional? Can NCLT remove the resolution professional for non-satisfactory performance? Yes, it is possible, even though he has not done any misconduct. Okay, even though he has not done any misconduct, but still NCLT can remove the RP if the performance is not satisfactory. Then sir, there is one case, that means the company, the directors have issued check on behalf of the company, the check got bounced and they have initiated criminal proceedings under Negotiable Instrument Act, whether it's going to get the moratorium when the company is in IBC. Okay, so court told no, NI is totally different, Negotiable Instrument Act is totally different, and that is against the directors of the company, even though it's on behalf of the company only, but the case directly will come to the director, so director have to go to jail. So IBC moratorium will not be excuse for the people who have issued check, which check means like, no, it's a company's check only, director signed it. Okay, so the moratorium will not applicable there. Okay, it's too different. So this is what the case studies which you have to remember. See, there are hundreds of case studies, but this is enough according to me. Basically it has given an idea, and the recent judge means like, percentage change, that 75% to 66%, that you please remember. They may ask MCQ. IBC, according to me, there may be more MCQ, at least 3 MCQ questions will be tested from IBC, and at least 2 will be in 2 marks. Okay, so read IBC carefully. Don't go in detail on case studies, case laws, etc. It is waste of time according to me. Don't go in search of case law books, etc. Just go through a normal logical case is enough. And my video, I guess I'm very crisp to the point. You share with people who you think you don't have actually sufficient time. You have to complete it, just 10 minutes for you for IBC case studies. And now all the best. See you. Bye bye.